Okay. Good afternoon, everyone. Today is April 12th. This is our afternoon 1:30 calendar. My name is Brad Gardner. I'm going to be the magistrate court judge presiding over this civil bench trial. We have 4 matters on the calendar. I'm going to call the calendar. When you hear your case call, please make your announcement. Position 1 is personal recoveries versus Drexel, Chandler, Ariel, is it Israel?
Yes.
And Mercedes McLaughlin. Looks like
that's the same.
Hold on, ma'am. Okay. So when the judge is talking, you stop talking. When I ask you a question, I will stop talking and listen to the answer. That way we don't have a confusion over what's being said. I see Mr. Nadler is here on behalf of personal recoveries. Mr. Nadler, do you believe that it would be beneficial for me to place you in the breakout room with Mr. Chandler and Ms. Israel, see if you can possibly resolve your matter?
I do, Your Honor. Your Honor, and it looks like Mr. Orm from my office is also on the call or on the Zoom. Can he be excused?
Yes. You got saved today. Have a good day, Mr. Orm.
Thank you.
We're on the fastest route.
Okay, I'm going to mute you, Mr. Chandler, Ms. Israel. And when I'm done calling the calendar, I'm going to place you in a breakout room with Mr. Nadler. And I'll explain that process when I get to it, okay?
Okay.
Thank you. Position number 2, Jefferson Capital. Looks like Exeter Finance versus Nikita Strickland.
Daniel Green for the plaintiff, Judge. I see that attorney J. Max Davis is on the other side and he's not here. I had a case with him last week and I know he filed a bunch of conflict letters. I'm not sure if he filed a conflict letter for this case or not.
Okay. Miss Mary, can you check on that?
Okay, I will.
Okay, thank you. So we'll hold and see if he's gonna, if he doesn't show or has a conflict, I'll grant a continuance in the matter and you could be free to go, Mr. Green. Position number 3, Midland Credit One Bank versus Deborah Jones.
Your Honor, if I may, can you tell me who the attorney is who's representing Midland?
It says Luke Stuckey.
Okay, that is not with our office. Just double checking. Thank you.
Okay. This case was placed back on the calendar, I think on January 18th, and there was a notice sent out in March, I think on March 22nd.
Judge, I think this is Mr. Medford's case. He just logged in.
Mr.
Hey, Your Honor, sorry, I was at a different court.
Oh, okay. Are you representing Credit One Bank?
Gabe, it's a Midland funding case that Luke was on.
Mr. Medford, which case are you here on?
I'm here on Midland Credit for Deborah Jones.
Okay. And do we have Ms. Jones here? Okay.
Absent, Your Honor.
Okay. Finally, position number 4, Cherise Reed versus Autotech.
Your Honor, the plaintiff is here, Mr. Reed is here, and his wife is in the, Ms. Reed is in the outside.
Okay. And is that your case, Mr. Holsey?
Yes, sir, it is.
Okay, do you think it would be beneficial for me to place the two of you in a breakout room to see if you can resolve this matter?
No, sir, I do not.
Okay. That completes the call of the calendar. I'm going to create breakout rooms. And I'm going to place Mr. Nadler and Mr. Chandler and Miss Israel in breakout room number 1. Okay. That breakout room has been created. Mr. Chandler, Miss Israel, you should see a link that you can click on for room 1. Go ahead and click on that and make sure you unmute your phone, and it'll just be you and Mr. Nadler in a room together. Okay, you can go ahead and press the link. Okay, thank you. Mr. Medford, we did not have an answer from Ms. Deborah Jones.
Right. I would move to strike answer and enter default judgment in the amount requested in the complaint.
Okay. Request granted. Answer will be stricken. And I'm presuming you're prepared to provide some evidence to me?
Yes, Your Honor.
I'm ready to hear it.
Sure. This is regarding a Credit One bank account. The account was opened September 19th of 2018, was charged off on June 4th of 2020. At the time of charge off, the
Okay,
balance.
Mr. Medford, speak
Sure.
a little bit slower because I'm writing everything down.
Sure.
All right.
Sorry. At the time of charge off, the balance remaining on the account was $855.38. Attached to our statement of claim, we provided a statement showing those liquidated damages.
Okay.
And additionally, in our statement of claim, we included a bill of sale showing the assignment from Credit One Bank to Midland Credit Management, Inc.
Okay. Just, I'm although it's all this stuff has been filed, I still need to hear the words.
Sure, I get it.
So what are you asking for a total?
Court costs are $100 total. We're asking for $955.38.
Okay, that'll be granted. I need you to draw up an order for me to sign.
Sure thing. Thank you, Your Honor.
You're welcome.
Is there an email I should send it to?
Yes. Send it to Mary.Moultrie, MOULTRIE at ClaytonCountyGA.gov.
I've got it.
Okay. So with that announcement, you can be free to go. You send it to us today. And I will sign it.
All right.
Okay.
Thank you, Your Honor.
All right, you're free to go, sir. Mr. Green, do you think you want to try to reach out to Mr. Davis?
Your Honor,
I'm sorry.
if he did not file a conflict letter, I guess I would.
He should have
I'm not really
served
sure
you
what
with
to do.
he should have served you with the copy.
Did he file one with the court? If he filed one with the court, then I'm okay with continuing the case.
Miss Moultrie is checking on that now.
Okay.
Okay. All right. So we'll stand by for that. We'll move to position number 4, Sharice Reed versus Autotech.
Your Honor, Mr. Reed is here present.
Okay.
Your Honor.
So, Mr. Reed, I only see Sharice Reed as the plaintiff in this case.
I thought I signed my wife's name as a witness. It should have been somewhere at the bottom. I mean, if not, though, it's fine. It's fine if not.
Okay. So your wife will be the plaintiff, and you said that you had intended to call her as a witness?
No, I wanted her as a witness. I'm the one that's going through everything. I just wanted her as a witness because she was there during everything that was going on and going through it actually as well. It's just my contact.
And Your Honor, if it pleases the court, his wife's name is Miss Johnisa Reed.
Okay. I may be mispronouncing your name, Mr. Reed. It's written here as Shereeze. Is that your name?
No, it's Sherreze. It's Sherreze.
Sherreze.
Yes,
Okay.
sir.
So I was mispronouncing it.
It's fine.
So it was filed correctly. If your wife is going to be a witness, we have what we call a rule of sequestration, which means she's going to have to stand out in the hall until it's time for her to testify.
That's fine. Yes, sir.
She's
Now,
not there, Your Honor.
okay. Now, I need both of you to raise your right hand for me, please. Do you swear or affirm the statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes.
Okay. So, Mr. Reed, as being the plaintiff, you have what's called the burden of production and persuasion, which means that you have to prove your case. And if I don't believe that you've proven your case, Mr. Halsey doesn't have to say anything.
Yes, sir.
Okay. So, sir, in just plain language, explain to me what you believe happened and why you believe Mr. Halsey should be held liable.
Okay, so the day that I spoke to him about my truck, my vehicle coming to him to fix it, I basically told him, I know about mechanics, I worked on my own vehicle, whatever the case is. And the reason why I couldn't do these particular jobs was because it would take too much and I stay in an apartment complex and I would not be able to do it there. So I sent my truck to him, and when I explained to him what the deal was, that it was basically making some kind of noise on the passenger side of the vehicle. And I sent the truck to him. So when he got the truck or whatever the case is, he called me. He said he didn't notice any sound or anything going on with the vehicle. And I'm like, okay, well, I have video, or the case is, and I can send you the video. And I have the proof of that in my phone or whatever the case is. But I sent him the proof and three different messages, 3 different emails. I sent him the proof. So a couple days later, he calls me and he's like, okay, Mr. Reed, we hear that sound, and that sound is actually louder than whatever the case is. Like, we can't hear anything with the truck on. And I'm like, okay, so do you know what the problem is? So he tells me, no, he's gonna give me a call back a couple more days later. And at this point in time, my aunt had just passed. So I was explaining to him that I really needed my vehicle back, in order to make it to the funeral or whatever the case is. So he's telling me, they're going to get to it when they can or whatever the case is. They're diagnosing it and everything is in effect or whatever the case is. So a couple of days later, he calls me and he gives me a bill of about $2,000 or $3,000 something dollars. And he's saying that it's a nut or something from the transmission had fell off inside of the torque converter, or the torque converter bolt or something fell into the transmission. And when he said that, I was clueless to what happened or what was going on. So I told him that I didn't have the money and I would be to pick up the vehicle for whatever the fees or whatever he had done already. I'll pay for that and I'll pick up the vehicle. So I get to him to pick up the vehicle, and it literally sounded like someone had dropped some change into my transmission. And like I said, I have the evidence of the video before that I sent to them. and the video of me picking up my vehicle and how it sounds. And the sounds are on two different sides of the truck. The sound that I originally sent him is on the left side of the vehicle. The sound that he gave when I got to my truck, the sound that's coming out of it, it sounds like changing. It's on the whole opposite side of the vehicle where they were diagnosing. They didn't have to fix anything on that side. They were diagnosing everything on the passenger side, which is where my alternator and everything else was, because they replaced the belt, and I have the paperwork with everything that they replaced on it. They were supposed to have replaced the belt and everything else. So as I'm driving my truck home after I picked it up and paid him $400, I get not even a mile away from his store or his shop, and the truck completely breaks down. After this, I call him. He tells me he's gonna fix it. I call him right when it happened. He tells me he's gonna fix it. He said, just get it towed back to his yard. I got it towed back to his yard for a couple of days later for him to tell me that the shop previously had messed up something on the vehicle that he didn't say anything about previously when he got the vehicle. But then he started saying that the previous shop had messed up the alternator, the rocker, and all this other stuff. So he refused to work on it again. So I got it sent to Nissan. And this is paying out of pocket. I got it sent to Nissan. Nissan wrote me up a quote of about $7,000. Basically, they drained the truck of engine fluid. So it had no oil, it had no transmission fluid. Basically, everything that they worked on that they replaced, they had broken. The rocker, the alternator was broken, and all types of other stuff. And the thing is, I contacted Mr. Marvin after I found out everything that I found out, how the shop told me, all the things that were wrong with the vehicle. There was no visible or any type of showing of leakage or anything of the vehicle. And I was out of the engine and almost out of a transmission. And then they told me that the nut that was found inside of the transmission was from a starter. So that had nothing to do with the transmission at all. And like I said, I have the paperwork of everything right here. And I just been paying money after money after money. Ever since my truck came from his shop, it's been at Nissan since then. And it was at his shop for almost a whole month. And it was times that I went to the shop and my truck was just sitting there after he said that they were working on it.
Why did you take your vehicle to Auto Tech?
Okay, so originally I was going through a warranty company called Endurance, and they gave me 3 shops that I could take my vehicle to. And out of those 3 shops, I took it to the first shop, which was Hoffman Tires. That was in Fayetteville. When I took it to them, they replaced the alternator, a brand new alternator. And I don't know if I submitted that, but they replaced the brand new alternator, replaced the serpentine belt, and a couple of other things. And that's proof of that. So after it went from that shop, I got my truck back and it was leaking coolant. They punctured the hose, so it was leaking coolant. It was smoking. So I sent it back to them and I got it back like 2 days later and it was shaking. That's why I sent it to him, because out of the 3 shops that I had to go to, those are his shop and Hoffman Tires were the only 2 shops that were close to me. Everything else was past Atlanta. And the truck barely was moving. And the company I was going through would only pay for so many amount of miles or whatever the case is. So he was my only other option that was close to me. So, and as I was telling him about Endurance and that being the company that I'm going through or whatever, it's like he was just over talking me, trying to make it seem like I just didn't know what I was talking about, or the company just wouldn't pay for everything, or this, that, and the third. And I explained to him, I said, okay, I might not know everything, but I do know that the company said they would cover certain things. And it seemed like everything that he hit me with that I had to pay was stuff that they did not cover.
So, did you approve the work before the work was done on the vehicle?
Only thing I approved was the AC compressor, was for him to fit this, to diagnose the sound of the engine, whatever that sound was. That's what I approved to him of doing. But after approving of that is when everything started messing up. That's all I approved was the diagnosis. And that's what I paid him for, the diagnosis. And the AC compressor and one other thing. I paid him for those 3 things or those 4 things. But that was it. And that was all I authorized, because like I said, I was telling him what I felt like was wrong with the vehicle before it came. Now, he overtalked me, telling me he know what will probably be the problem, whatever the case is. I just had to get the truck to him. as the truck was hit at his shop for that whole month or so, almost a month or so, not one time did he call me and tell me, okay, Mr. Reed, I got your truck running, or okay, Mr. Reed, I figured out what's going on. Every time he called me, it was like a problem after another problem after another problem that did not make sense, because like I said, none of those problems were going on with the truck before it got there. Nothing. I have video evidence of how the truck sounded, riding and everything before it went to his shop. And I have video evidence of everything after it left his shop. Like literally after I paid him, got to the vehicle and crunk it up.
Before you left the shop, did you go over to work with Autotech, any technician or anyone from Autotech?
No, being honest with you, he acts like he's so busy the whole time, and he was acting like he had so much going on. Only thing
Mr. Reed, I need you to be as direct about answering my question without involving those allegations, okay?
Yes, sir.
So, okay. Mr. Halsey, do you have any questions of Mr. Reed?
No questions, sir. No.
I'm gonna let you.
I'm sorry.
Hold on. I'm gonna let you speak, but we just have to go through this
Yes,
step. Now, Mr. Reed, what is it that you expect your wife to testify to? We call that generally proffering evidence, because if you've been the person dealing with Mr. Halsey or with anyone from Autotech, all she can do is tell me the same thing you can tell me.
Well, then, yes, it's no point. I got you.
Okay. Is there any other evidence that you want to submit?
I have everything actually paper right here, and I have some stuff on a USB drive, and that's basically it.
Have you shared this evidence with Mr. Halsey?
Being honest, like I said, I tried to contact him before I even filed this lawsuit because of the bill that I got hit with, and he told me he had nothing to do with anything. So I do what I got to do. That's exactly these were his words.
Okay, I'm gonna ask the question again. Did you share any of these documents with Mr. Halsey?
No, sir.
I'm gonna stop you right there, Mr. Halsey. Let me hear your side. Halsey,
Yes.
I'm sorry.
Halsey, yes, sir. On the day he brought it in, there's a lot of discrepancies in what he's saying, but I'll just go through the sequence of events. He brought it in on 8/25/21. The work was completed on 9/7, and he paid for it on 9/8. There was a warranty that paid for an idler pulley, an air conditioning compressor that we had to put on the car, and he had a deductible and some other things that they would not cover. We started listening to this vehicle at first when it got in the shop. We could not drive it. It was making so much racket that we were afraid to drive it. So we did not. We brought it in the house to put it in the building, and that's when we found that the compressor was making all this racket along with the idler pulley. So the belt was also damaged. Now we saw that alternator had been replaced, but the belt was being torn up by the compressor. So the warranty authorized $840. Mr. Reed authorized $516.80. When we got these items on, we went to test drive the car. It was so much noise to start off with. We don't know if this secondary noise we started hearing was there already. We have to assume it was. But the bottom line of this is that we took a borescope and put it. You may see a picture of the camera picture that we've got attached to the paperwork. We used a borescope to go in to the bell housing between the transmission and the engine, and we could see a stud on the transmission torque converter that had no nut on it. So we were assuming that nut was laying down in the bottom, and that was making all the noise. Now, the only way anybody can physically be to that point is to remove the transmission from the engine. So there's nobody externally that could ever cause this to happen. We have said, plus I see the course documents about the being at the dealer says the same exact thing. The transmission has to be removed to find out what happened. But we were working on the front of the engine about 3 feet away from this transmission nut that's off in the bell housing. Completely sealed up item in that area that we would physically not be able to touch. So Mr. Reed didn't like my answer about that. And you can see it wasn't a month. And then he took it to the dealership and their paperwork says the same thing.
Okay.
Now, technician is here with me and listening. So if you have any questions for him, he's welcome to.
Not yet. Mr. Reed, do you have any questions for Mr. Halsey?
Actually, I do. About you saying about the sound.
Now.
I'm sorry. I don't know how it works. I'm sorry.
No, I need you to just ask questions, right? All right.
So did I not have to send you videos of the sound because you said you did not hear it?
That doesn't ring a bell with me nor the technician. And I've got on here on my ticket that we heard the noise and deciphered what it was. We couldn't even drive it because the noise was so bad.
Judge, I have emails sent and received from them about this.
We hear the noise. We have no argument about
this video. They said they did not hear any noise. I had to
hold on 1 second. So the noise is not really an issue to me. Okay.
Okay.
Any other questions?
It was about, I forgot what he said. I'm sorry. I forgot what he said.
Okay. So
that's what I'm sorry. I didn't mean to cut you off.
Go ahead.
It was about the transmission thing. They said at first that I'm asking questions. Okay.
Yes.
Okay. So did you not diagnose the transmission before you called me about it?
Well, I wouldn't have been able to call you unless I had an answer for you on that. And on 9/14 is when we have determined that the noise was happening inside the transmission bell house.
Let me stop you guys real quick. Always, if there's Mr. Nadler, do you have an agreement?
In essence, we sort of do, Your Honor. What we're going to do is I am going to send the defendants in this case a whole packet of documents that I want them to look over. And we've agreed to continue to talk to resolve this. And we can set the matter for a different date. That would be greatly appreciated.
Okay, I'm going to need you two to possibly hold on until we can get a date for you, okay?
Sure.
All right.
Thank you, Your Honor.
You're welcome. I'll place you back on mute.
Judge,
Yes.
we can't get a date for him. He's gonna need to submit us a motion for continuance, and the clerk's office will have to give him one.
Okay.
Because we don't control that calendar.
Okay.
Your Honor, would you like me to go ahead and I'll have somebody file a motion for continuance by agreement today?
Please send it to Miss Mary so that we have a copy. Because sometimes if you send it into the clerk's office, it may get placed somewhere.
If I can just have her email address, that would be great.
It's in the chat.
Oh, great. Thank you.
So,
Thank you.
Mr. Chandler and Miss Israel, did you hear the announcement made by Mr. Nadler?
Yes, sir.
Yes.
Is that what you two agreed to do?
Yes,
to
sir.
continue this? Okay, so the request for a continuance is going to be granted. The two of you can be excused, and you will receive a court notice from the clerk's office.
Okay.
Okay?
Thank you.
All right. Mr. Green, I saw you on the phone. Were you able to work your issue out?
Well, no, Judge, I was waiting for Miss Moultrie to see if a leave of absence was filed, I believe.
Yes, sir.
Okay.
We just found out a leave of absence was filed.
Okay, thank you, Judge. Then I don't object to the case being continued.
Yeah, they'll notify you of the new hearing date.
Okay. All right, so you can be excused, Mr. Green.
Thank you.
You're going to receive notice in the mail. Mr. Nadler, you can be excused also. Just send that over so that we'll have a copy of it. And then when the clerk's office finds the due date, you will get notice.
Thank you, Your Honor.
So-
Much appreciated.
So you can be excused. All right. Okay. Sorry, I try to keep things moving so that people are just not wasting their time. Okay. I was at the point where I was going to start asking some questions, if that's okay.
Yes, sir.
I'll begin with you, Mr. Reed. My understanding from the testimony is that this vehicle was having some mechanical issues before you took it to Auto Tech, correct?
Yes, sir.
Do you have any proof that the that or evidence to present that the problems with the vehicle were caused by this prior shop?
So you mean like before and after type situation?
Well, the question I'm trying to get at is that in order to be able to prove your case, you have to show essentially that the damage was done by Auto Tech and not by someone else. Because the vehicle was having mechanical issues before it was sent to Auto Tech, and you testified about that there were some drivability issues with the vehicle, that causes me concern as to whether the damage that's obviously there was caused by this prior shop or by Auto Tech.
Okay, so the evidence that I have from the shop before Auto Tech, this is everything basically that they did.
I can't see that, but you can tell me.
Okay, so basically it says that they installed an alternator. They replaced the alternator, power steering belt, and removed and replaced power steering belt. Well, yeah, the power steering belt. That was the only thing that they stated was wrong with the vehicle. That was the only thing that they diagnosed it for, which was the alternator and the belt. After that, like I said, the only problem that I had was just a little, it shook a little on acceleration. That was it. I had nothing else in that little sound. So after that, Auto Tech gave me a receipt of what they fixed. And that was, I'm sorry. And the only thing that they fixed was, well, that they said they fixed was the belt pulley, the idler belt pulley, the serpentine belt, AC compressor, and a filter dryer. This was the only thing that they said that they replaced or whatever. And then they said that they replaced the AC compressor for being noisy, replaced HVAC filter dryer, AC recover, recycle, and recharge system, DNC parts to gain access for camera scope, can see nut off a torque converter stud, will have to R&R transmission to repair it as necessary. And the labor of that was $1,365. So basically, when it left this shop and went to Nissan, this is what all was wrong with the truck when it got to Nissan. It was basically, the engine basically had no oil. There was no oil, no fluids in the engine. They had to replace the alternator again, replace the alternator housing. They had to replace the battery, the assembly blowers, the insulator, the engine mounts, the gasket, the manifolds, like everything, spark plugs, rubber rings, blow hoses, every gasket, rocker covers, everything had to been replaced after it left from Auto Tech. And this is just coming from a tow truck, from a shop on a tow truck to another shop. And literally on the 18th of September, I think this was. And this is all the stuff that they replaced.
So, Mr. Reed.
Yes, sir.
These cases are notoriously hard to prove. Essentially, in order to prove your case, you would have had to have the truck towed from Auto Tech, have a new technician look at the truck, repair the truck, and then come back to testify that in their opinion, the damage was done by Auto Tech.
Also, I needed a mechanic to testify.
Yes. Well, not even the mechanic, because that doesn't always carry the day. So let's say, like, I'll use this analogy from a medical. Hold on, sir.
Sorry,
Hold on. I'm going to let you talk.
I'm sorry.
Let's say that I'm not feeling well, and I go to the doctor, and the doctor does some tests on me, and the doctor says, hey, you have, let's say, heart condition, or you have kidney damage, you have something. And the doctor then works on my kidney. But I say, well, my foot is hurting after I had surgery. So I think the doctor hurt my foot while I was in surgery for my kidney. May or may not have happened. But in order for me to prove that, I would have to have a doctor to look at my foot and explain how the damage to the kidney led to the damage on the foot. They basically say correlation is not causation. Because certain things have happened, it doesn't mean one was caused by the other. Because this vehicle had damage and issues before you took it to Auto Tech, you would have to be able to, again, show that it was solely Auto Tech. It wasn't anybody else. It was just Auto Tech. And I know you're saying, well, there were different things that happened. Doesn't mean that Auto Tech did it. And when I said that's the plaintiff, you have the burden of production and persuasion, which means you have the burden of producing evidence that shows that Auto Tech caused the problem. And then you have to persuade the decision maker, which is the judge, that the issues that happened were solely there because of Auto Tech. You've presented evidence of problems, but I don't find your evidence to be persuasive that the damages that were done to your vehicle were solely done by Auto Tech. So I'm gonna have to rule against you.
But what if, all right, so I understood your analogy when you were saying come from one place to another. My truck literally was towed from Auto Tech to the Nissan dealership though. And Auto Tech didn't diagnose it with any of these problems. It got diagnosed when they got the Nissan with all of these problems from Auto Tech.
The testimony I heard was that you drove the truck away from.
No, I drove it from Auto Tech. I know, you heard me right, but you didn't hear everything. I said I drove it from Auto Tech and it broke down.
What
So
did
I
I
had to
not?
get it-
What did I not hear, Mr. Reed?
No, what I'm saying, I drove it from Auto Tech, right?
You drove the truck from Auto Tech. The truck got a short distance away from Auto Tech, and based upon your testimony, the truck broke down.
Yes,
right?
and it got towed back to Auto Tech. It got towed back to Auto Tech. That's what he said. He even said it. It didn't leave his shop until September the 18th. After it broke down, after I paid him that $400 some and it broke down, it got towed back to his shop. He told me he would get it fixed. That's when he called me a couple days later and told me that I would have to take it back to the original shop. That's exactly what I said. I swear to you, Your Honor, that's exactly what I said. And it was told from Auto Tech directly to Nissan. Directly to Nissan. It didn't go anywhere else.
Mr. Reed, I hear what you're saying, but you're not listening to me. Okay? If this was a brand new, hold on, Mr. Holsey. If this was a brand new car fresh off the lot, and you took it over to Autotech to have, let's say, have the oil changed. And then the issue that came from the truck was no fluids in there. You took it there for them to change the oil. They didn't change the oil. You have evidence that the car had no problems before it went to Autotech. Your problem is that you have a vehicle that was having problems before it even got to Autotech. Okay, and I'm sorry, Mr. Reed, but I can't, I have to follow the law. Okay, that'll be the ruling of this court. This case will be dismissed and the parties are free to go.
Thank you, Your Honor.